Welcome back, class. We're going to continue. This is our second video on the formation of sales and lease contracts, and we're going to continue. We're going to pick up with contracts for goods and services, determining when those are covered by Article 2. But I do want to draw your attention to Nautilus Insurance Company versus Sheeran Investments, which is the first case in this chapter. It has its own case note, full case note box. And in this case, this involved the sale of the Attic Bar and Grill in Omaha, Nebraska. And this case involved the distribution of insurance investments, the insurance policy after a fire at the bar, right? And so Sheeran Investments and Blasini Incorporated agreed to buy the business assets of the Attic Bar and Grill in Omaha. It required Blasini to make a down payment and monthly payments, so it's just a leveraged transaction, until the purchase price for the bar was fully paid. Blasini obtained insurance on the property from Nautilus Insurance Company. Less than 3 years later, a fire damaged the property. And this property includes business assets such as furniture and equipment. All right, goods, tangible and movable. The purchase price wasn't done yet. This was 3 years in, and he was still paying the business down. Nautilus, which is the insurance company, then files an action against the defendants, including Sheeran, to determine who is entitled to the insurance proceeds for the damage. This is basically a way of you implead these defendants, right, to basically get at who the owner is, because Nautilus doesn't know who has title to the goods. In the case of Blasini or Sheeran, even though they're not in direct dispute at this point yet. Sheeran, the owner, the court concluded that Blasini had failed to consummate the purchase agreement. And declared Sheeran the owner of the personal property. Sheeran was the seller, Blasini was the buyer. Blasini appealed, arguing that the title to the Attic's assets had passed at the time of sale. It's interesting to note, they said that, quote, that Blasini had failed to consummate the purchase agreement. And the way that I read that, I'm thinking it's as if they're saying that he'd failed to execute the purchase agreement, because the purchase agreement was an executory state rather than an executed state, right? And if you recall from BIZLAW 1, an executory contract is one where obligations remain to be fulfilled. And an executed contract is one in which both parties have fully performed, right? So because Blasini had not fully performed, presumably he was in the process of performing by paying on a monthly or quarterly basis, however they set it up, that because he had not fully performed, he is not the owner of the title to the goods, right? So in that case, the provisions of the court on appeal said the provisions of the UCC apply to the instant purchase agreement. The purpose of the agreement, that's basically saying that Blasini must have title. If the UCC applied, then he'd have to have a title to the sale of goods, right? The items specifically designated in the agreement were the furniture, security systems, Aloha accounting system, television, music systems, refrigerators, kitchen equipment, food, basically the whole shebang, right? They went through and they listed on the purchase agreement as an attachment all of the things that were assets of this business that were going to be sold, right? The ledger attached to the agreement lists several of the bar's items and their values, including a number of those items, including various items of equipment. I don't have to go through the list. With a purchase price of $150,000, which accounted for movable items of the bar and no real estate, intellectual property, or goodwill. So these are all goods. Everything that's claimed here is goods. Under UCC 2401, this is another statute, UCC 2-401, regarding title, unless otherwise explicitly agreed, where delivery is to be made without moving the goods. Here, the goods were not to be moved. The business was sold as a going concern business. So where delivery is to be made without moving the goods, if the goods are at the time of contracting already identified, and no documents are to be delivered, title passes at the time and place of contracting, meaning it passes when they sign the contract, and he took on that obligation to pay Sharon for the Attic Bar and Grill. So, Blasini contracted to purchase the business assets of the bar, evidenced by the signed purchase agreement. No physical delivery needed to be made because Blasini was to assume operation of the bar in which the goods were located. Under UCC 2-401, which I just made reference to, title of the goods passed to Blasini at the time of contracting. The purchase agreement made no provision for when the title passed to Blasini. Therefore, irrespective of whether Blasini paid the purchase price, Blasini became the owner of the property in the purchase agreement. Now, they may still have a dispute about whether Blasini performed his obligations, but that's not the issue for this particular appeal, right? Blasini would then basically have right to that insurance proceeds. Presumably, he would use some of that to pay off Nautilus investments, since he had the risk of loss. I mean, not Nautilus, I'm sorry, he'd pay off Sharon, who was the seller of the company. All right, this brings us to contracts for goods and services. So we know it has to be a sale of goods, and that if that is true, the title has to pass. We've looked at 3 rules that basically represents this. UCC 2-106 regarding sales, UCC 2-107 regarding severance, and UCC 2-401 regarding title. All right, so sale of goods and passing of title. All right, so here we have to look at the situation that consistently arises. What if, instead of goods and real estate, which we just talked about, what if it's goods and services, right? Goods and services combined. There is this thing called the predominant factor test. Whichever feature predominates in the contract, and this is sort of like a weighing test, another one of those, I don't know, I guess it's sort of like the reasonableness standard that sort of floats around and haunts every beginning law student. It's sort of like that, but this predominant factor test looks at what is the contract predominantly or primarily about, right? So Gene and Martha Janich agreed to sell Festival Foods, which was a concession business, to Lindsay and Luann Nafzinger for a price of $150,000. The deal included a truck, a trailer, freezers, roasters, chairs, tables, a fountain service, signs, and lighting. The Nafzingers paid $10,000 down, with the balance to come from a bank loan. They took possession of the equipment and began to use it immediately in Festival Foods operations at various events. After 6 events, the Nafzingers returned the truck and all the equipment and wanted out of the deal because the business did not generate as much income as they expected. The Janishes sued the Nafzingers for the balance due on the purchase price, claiming that the Nafzingers could no longer reject the goods under the UCC. All right. The Nafzingers claimed that the UCC did not apply because the deal primarily involved the sale of business rather than the sale of goods. So what was being sold? Festival Foods business or the assets that were needed to launch the Festival Foods truck. The court found that the UCC governed under the predominant factor test. The primary value of the contract was in the goods, the things that they needed to operate the business, not the value of the business. The parties had agreed on the essential terms of the contract, such as the price. Thus, a contract had been formed, and the Nafzingers had breached it. The Nafzingers had taken possession of the business and had no right to return it. All right? So, what is the lesson that we learned here? The sale of a business, even if it enumerates the assets that are specifically sort of going to be passed on, may still be the sale of something other than simply just assets. But they had no right to return the business. right? Even though that contract involved the sale of a lot of assets. Or rather, maybe a better way to say it is that the sale of the assets of the business, the fact that it's a business does not mean that it's not covered by the UCC, right? If that business had been primarily comic book characters or patents, copyrights, trademarks, right? This wouldn't have been covered by the Uniform Commercial Code. It doesn't necessarily mean it wouldn't have come out the same way, right, with the NAV singers having breached that contract. But you can look at that as that's the first example in the chapter, is the NAV singers, all right? Thank you for your time in this second entry into contract formation, and please respond to the prompt, and I'll talk to you soon.